सबसे पहले तो मैं इफ़ यू डोंट माइंड मैं ज़्यादा फ्लुएंट नहीं हूँ हिंदी में।
जी।
न्यायिक प्रणाली में अच्छी बातें भी हैं और कुछ खामियां भी हैं।
जी।
और सबसे बड़ी चैलेंज ये है, ये नहीं कि खाली एरियर्स हो या वैकेंसीज हो, इंफ्रास्ट्रक्चर की बात है। सबसे बड़ी चैलेंज है कि हमारे जो कि प्रोफेसर साहब ने हमें बताया, माधव मेनन साहब ने, कि जो यंगर जनरेशन ऑफ लॉयर्स आ रही हैं, दोनों किस्म के आ रही हैं, सभी किस्म के आ रही हैं। और ये एक बहुत बहुत पॉजिटिव अहम डेवलपमेंट ये है कि जो लॉ स्कूल से आते हैं वो बहुत अच्छी तरह से ट्रेन होते हैं। और मैं अक्सर ये बोलता हूँ, कोर्ट में भी बोलता हूँ और बाकी मौक़ों पे बोलता हूँ, कि जिस तरह से 15 या 20 मिनट में अपनी सबमिशन ख़त्म कर सकते हैं, उस तरह से उस किस्म का ट्रेनिंग नहीं है, ना इंक्लिनेशन है हमारे इस्टेब्लिश्ड लॉयर्स में। और ये सबसे बड़ी हमारी कमी है कि हम टाइम मैनेजमेंट नहीं कर सकते, और टाइम मैनेजमेंट के साथ साथ हमारी डॉकेट मैनेजमेंट नहीं होती। नाउ many times I wonder where would be Mr. Madhav Menon, and I entirely support him that one must be optimistic. But do we as a system have a perspective plan? And are we seeing where we would be and what the courts of 25 years later would be? How much of courts have taken to technology? How much of lawyers have taken to technology? And I'm afraid that although Delhi High Court has been the driver in technology in terms of having the first paperless court, and now we have about 10 judges working paperless, lawyers are not. Lawyers don't take to technology. And we have not been able to convince them. Now, we adopted a mode of trying to convince rather than impose. Now, without convincing, I hardly see, and many of you appear in the courts, and I don't see you coming with iPads or ePads. The point is that it's not iPad which is, we need not be slavish to technology. But what technology does is something which you can look for yourself. If you can look into 15 volumes in one small iPad or a small laptop, and then have all of them open at one time, you are enabled. And if coupled with that, if you can make your submissions in advance, and some of these techniques which Professor Menon mentioned. Now today, what is the single most outstanding success of law schools? The ability of the children and the lawyers who emanate from them to be able to wrap up their arguments, present the salient points, present memorials in a particular word limit. Now this is all lacking. Now, it's not that it is not impossible, this can be done, but that inclination is not there. There is no incentive, there is no disincentive. As long as we allow this thing to go on, I'm afraid we will have errors. We will have all those things which are plaguing our courts. And yes, I entirely agree, we do need an overall civil procedure reform, and not tinkering with certain aspects of it and speeding one part of litigation or the other. I just won't, this is not the occasion, but I could only say that once you fast track a particular kind of litigation and say that so and so judge or so and so judges will do it, it's a double-edged sword. If there are a large number of those cases, I can give you an example of arbitration. If you say you'll have one arbitration judge, you will have all the arbitration cases go to him or her. In Delhi, we have 3,000 cases filed every year. So how will that one judge decide it? Likewise, you say one judge will decide all offenses, sexual related offenses. In one court, each court, you have 5 court systems or 9 court systems. The sex related offenses may be huge in number. Therefore, you may not arrive at the solution. Therefore, this is where the structural part of it has to be worked out on a dynamic basis. I don't think I should go further than that, because the occasion is different, and I'm really honored, proud to be here, privileged to be here to be with Professor Madhav Menon, who, and I'm absolute, the record is straight, it's correct. among the law teachers, I think he's a pioneer to receive the Padma Shri, be publicly honored like this. The only other person other than lawyers and some judges who have been honored is, I think, Pandurang Vaman Kane. He was given a Bharat Ratna, and he was again a law scholar. And scholarship and value for law teaching has all but vanished. I mean, I realize now because I've been on this wonderful project called the Courts of India, and I found that even 50, 60, 70 years back, you had great figures, whether it was an Ashutosh Mukherjee or a Maurice Guire or Jayakar, or you name anyone, they all were vice chancellors. And I think even Jagan Mohan Reddy was a vice chancellor. So was Justice Gajendra Katkar. So this link between academics, lawyers and judges was a very organic one. Somehow that has broken. And I hope this is re-established. And I hope we in the courts respond and also allow law professors, law teachers to come in and file their briefs. We will have great inputs. And sir, I think you would be heartened to know that in our Judicial Academy, which I've been heading for the past 3 years, in the last 6 or 7 years, all the chairpersons, those who head the academies, are academicians. So we have taken a cue from that, and at least personally I feel I'm a strong votary for law teachers and academics also interacting with judges at the stage of training. I feel there is a invaluable input there, and at least our judicial officers in Delhi, I think, benefit from it. Thank you.